Federal investigations have ensnared many of Donald Trump's most senior aides, and as prosecutors probe deeper into the remaining senior aides, as well as the people at the Trump org, some of the names that are left in both worlds are obviously Donald Trump's own family. Now, many prosecutors are actually especially cautious when it comes to splitting families against each other in a probe, but not this one. The hardball federal prosecutor, Andrew Weissmann, many call him Mueller's legal pit bull, and some of Trump's most enthusiastic legal defenders have tougher words for Weissmann than even for his boss, Bob Mueller.
I've called Mr. Weissmann the poster boy for prosecutorial misconduct.
He has chosen his Jack the Ripper-like leader, Andrew Weissmann.
Guess what? Weissmann is a legal nightmare. Weissmann, guess what? He's a legal tyrant.
Andrew Weissmann is a very, very powerful weapon in the government's arsenal. I don't like Andrew Weissmann heading this prosecution.
That was Trump's former lawyer. He doesn't like it. Well, that brings us to tonight's special report, the reason why Team Trump fears Weissmann and what it actually says about the future of Trump's family and how the probe may reportedly look at people as it draws to a potential close. So let's get into it. Weissmann, known for tough and sometimes controversial tactics. Lately, Trump allies have seized on, for example, this new footage of Roger Stone's home raid to try to impugn this investigation. Well, it was a Weissmann operation that first deployed a pre-dawn raid back on Paul Manafort's home in July 2017.
With absolutely no warning, FBI agents showed up before dawn to search the suburban Washington, D.C. apartment of Paul Manafort.
Raiding a home in the middle of the night is an indication of a very serious criminal case and criminal investigation.
Justice Department guidelines require agents to pursue evidence by the least obtrusive means possible. Sending armed agents to his bedroom door in the middle of the night is not the least obtrusive means possible.
Weissmann honed his hardball strategy in one of the most far-reaching, aggressive, and actually controversial prosecutions in modern American law, the Enron investigation. That probe was high stakes because President George W. Bush actually had deep ties to that Texas energy company. And so his DOJ tried to show there'd be no favoritism, so they appointed a special task force run by the FBI director at the time, Bob Mueller. That was Bush's proof this was going to be a tough probe. And then Mueller needed a point man to show it was going to be a tough probe, and he chose Weissmann to lead a, quote, elite team of FBI agents and federal prosecutors to investigate and prosecute any crimes related to Enron. Now, what was true then is very relevant now in the Mueller probe. Picking Weissmann meant you would get very tough prosecution, and maybe controversially so, because he's widely known for being effective and controversial. And that is based on three major tactics. Keep an eye out for these as we see where this whole thing goes. One, he supersizes even seemingly small offenses to play hardball. Two, he has managed to flip even hardened criminals into cooperating witnesses. And three, he charges targets that many prosecutors actually avoid, like entire corporations or defendants' own family members. I repeat, defendants' own family members. Now, those first two tactics are pretty widely used. The third, as you may know, isn't. And during the time that this Enron prosecution was going on, there was a top DOJ official, James Comey, someone who, of course, is relevant now in the Russia probe as a DOJ official who stood up to Trump, which we know the president didn't like.
James Comey was unfair to the people of this country. I think what he did was a disgrace. I think he goes down as the worst FBI director in history by far. There's nobody close. Director Comey was very unpopular with most people. He had the very poor performance on Wednesday. That was a poor performance. He was grandstanding all over the place. He's a showboater.
That same Comey that the president didn't like, well, history has thrust him as a key figure into this probe where Weissmann works. And Comey was quite public at the time in his praise for Weissmann.
I'd like to thank Andrew Weissmann, Deputy Director of the Enron Task Force, who's standing around the room someplace. I want to thank and congratulate Andrew Weissmann, her deputy. Let me thank the Enron Task Force, in particular Andrew Weissmann, who is the head of our Enron Task Force. He and his brilliant team are in Houston today, where their hard work continues.
And you can see Mueller off to the side there while Comey talks. He often avoided those microphones. Now, that hard work, as Comey put it, led to some hard calls, like whether prosecutors should single out just bad employees or indict entire companies. Now, that's controversial because if it sends the company to jail, well, You could think about it. It's like the company goes out of business and innocent people lose their jobs. But Weissman's team decided that the evidence of a criminal enterprise in the Enron case was so strong, forget it. They would indict the entire accounting firm, Arthur Andersen, that served Enron. And they initially won that case.
The Arthur Andersen accounting firm was found guilty in a Houston, Texas federal court today of obstructing justice in the Enron investigation.
This case was really about a simple principle, which is when you expect the police, don't destroy evidence.
Now, that actual indictment was controversial for the very reasons critics warned about. Thousands of employees did lose their jobs when the company shuttered. And after that conviction, ultimately, the Supreme Court unanimously overturned it, a legal ruling that part of the strategy just went too far. Indicting entire corporations is one thing. Indicting defendants' families is another. Now, in general, federal guidelines do discourage prosecutors to use tricks to pit family against each other. There's also a spousal privilege, which generally protects a spouse from being forced to testify against their partner. Now, Weissman didn't break those explicit rules, but let's be clear. He took an aggressive stance by indicting the wife of Chief Financial Officer Andrew Fastow on a misdemeanor when Fastow was resisting pressure to plea.
Today, the Enron Task Force's continuing investigation has led to the unsealing of 3 new criminal indictments and a 6-count indictment against Lee Fastow. As the indictment charges, she and her husband and others were part of a conspiracy to maintain control of an asset that Enron had but couldn't keep in name.
Now, that was hardball. Ms. Fastow wasn't exactly running Enron. She wasn't widely considered a major player. Reuters reported that Weissman was trying to gain leverage from indicting the wife in that case. Eventually, Fastow did plead guilty, turning over documents that proved Enron was participating in accounting fraud and that the CEO knew about it. In other words, Weissman and Mueller, the folks playing hardball, they would argue they got where they needed to go. And those documents were crucial to the case. Weissman had no reservations about pursuing someone that he thought was guilty and could help the case. Former U.S. Attorney Barbara McQuaid says Mueller's team may also be looking at statutes that are used against mob bosses to sweep up potentially family members involved in a conspiracy if they are. In other words, racketeering potentially against Trump's family. And Weissman did some of that kind of prosecution with Enron. He's also known for dangling the threat of even more jail time to keep people in check and casting a wide net. 114 people he named as unindicted co-conspirators. But then again, remember, critics point to the Supreme Court's unanimous rebuke of Weissman as a sign that these tactics have their limits. And you could argue that those critics have a point, because if this hardball were deployed against you or your family members, you might think it was pretty unfair. On the other hand, Weissman's defenders say this is what they have to do. They're not dealing with normal people who are complying. They're only using these tactics with people who systematically commit alleged crimes and then commit new alleged crimes to hide their old crimes, a kind of a rabbit hole blizzard of crimes and cover-up designed to defeat the one lawful force that would exist to catch them. And faced with that, Weissman, who again at the time was working under Mueller's supervision, his argument is, look, we're going to come hard at the cover-up just as hard as we'd come at the original crime. In fact, Weissman at the time was arguing he was basically up against a criminal enterprise. Whether he faces one today, of course, is an open question. We're not reporting that tonight. But he's already part of a team that has indicted people on obstruction crimes and cover-up, which include, as you know, the president's campaign chair, deputy campaign chair, national security advisor, longtime lawyer, and longest-serving political advisor. Many on similar cover-up style crimes. And there's one thing that Weissman's critics and allies agree on. If you remember nothing else, we all know this. This pit bull prosecutor that Mueller tapped, Mr. Weissman, and his team, they're not even done sifting through the rubble.
The Enron Task Force is continuing to sift diligently through the rubble that was Enron, piece by piece, scheme by scheme, and lie by lie.
I am now joined by acclaimed business journalist Bethany McLean, a contributing editor of Vanity Fair, author of several books, including The Smartest Guys in the Room, The Amazing Rise and Scandalous Fall of Enron. You've been at this story from the start. Thanks for being here.
Thanks for having me.
In your view, with the long eye of history, what did Mueller and Weissmann learn through the hardball tactics of the Enron probe?
Well, I think that in some cases they're necessary and helpful. Of course, necessary and helpful, as you pointed out, depends on which side of the aisle you're sitting on. But it really turned out to be pivotal in the case of Enron. The ability to convict Jeff Skilling rested on Andy Fastow's testimony. And if Fastow hadn't cooperated eventually with the investigation, history would have been different.
And that's a lot of history. You're saying, though, Fastow's cooperation was a product of Weissmann going after family?
Well, Fastow had been indicted and was refusing to plea until Weissmann indicted his wife in a superseding indictment that brought additional charges against Fastow and others, but also included his wife. And given that the couple had young children at that time, it could have meant that they both would have been away in jail with no one home to care for their children. And it's indisputable that after that, Andy Fastow did plead guilty. And when he pled guilty, this document turned up that was one of the clearest indications of accounting fraud at Enron and a key link to showing that Jeff Skilling knew about the accounting fraud. And until that point, the document hadn't turned up. The only copy of it was in a safe deposit box that Fastow said he and his wife found when they visited their bank after he had pled.
It's fascinating, and you put your finger right on the details there. So what you're saying is, on the one hand, this was key to securing a conviction that many legal experts and certainly people concerned about corporate fraud thought was a very good thing, and the hardball got them that. On the other, you're talking about tactics that, to many people, if you knew those folks or were friends with them, you're talking about the legal equivalent of orphaning their children.
Right. It's unquestionably a hardball tactic. I don't think Lee Fastow would have been charged if it hadn't been for the possible benefit she could bring in putting pressure on her husband. Her wrongdoing was minimal, especially in the scope of what happened at Enron.
Well,
so it was clearly a tactic.
Before I lose you, I want to play one more thing, which is this is part of why some of Trump's allies are so obsessed with Weissmann. Donald Trump's longest-serving lawyer, Jay Goldberg, who served before Cohen, told us on this very show that they had some sort of special arrangement. Take a listen to this.
Mueller has agreed not to have Weissmann involved in any investigation of the president. That's a little known secret, but I found that out.
Who told you that?
Somebody on the president's staff.
That was a White House lawyer or a staffer?
Yes, a White House lawyer.
Was it Ty Cobb?
Well, yes.
A little deposition tactic there. We don't know if that's true. We just know that Trump's former lawyer there, Jay Goldberg, asserted it. Does that sound like something Weissmann would agree to based on your knowledge of his record?
No, that does not sound like it would be true to me. And just to put this in broader context, by the way, these cries of prosecutorial misconduct, prosecutorial overreach, they happen in every single trial. This one and the Enron case are just a lot more high profile than most trials, but it's not like it's new. People in the defense seats are always screaming that the prosecution is overreaching. So by no means is this some kind of fresh accusation.
Yeah, Bethany, you make such a great point, which is many criminal defense lawyers try to put the rest of the system on trial because they can, and it doesn't involve dealing with the evidence against their client. As you say, if viewers aren't following every trial in the country, they might think, oh, does this only happen with Mueller, Enron, and Russia? And as you say, not really. You were there from the start, your award-winning book. I really appreciate you coming on the beat to tell us about it.
Thank you.
Thank you, Bethany. Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.